In fact, I'd like to ask Dr. Feldman and his wife to come forward at this point.
So your answer, Mr. Chairman, is we're going to wait
as we go.
Okay,
right.
Thank you.
Representative
sit first, and then you can come up after him. I think the chairman said that I could respond to Representative Johnson. Representative Johnson, they've given y'all handouts describing what due process is. That's not what they do. They say they are informed of the charges against him or her. Dr. Stevens was accused in the summer of 2014. He had to try to figure out who the complainant was. The board has never told him. He had to try to figure out what the complaint was. They never told him. He never got formal, detailed charges about the exactly what the informant or the complainant said. He's never been given his file. You asked about whether the people that testify here are given sworn testimony. Dr. Collada said, well, we give them their file. It's May of 2018. The complaint was filed against Dr. Stevens in the summer of 2014. So that is, by my reckoning, that's about 3 years and 7 months, more than that. And our question to Dr. Collada, if he comes up again, if he'll consent to finally giving Dr. Stevens a copy of the file that's against him. It says the represented by counsel. You asked about whether he signed these consents, and the doctors do. The rest of the story is that when they're brought in, they don't have attorneys. They're asked into Cecilia Mouton's complex in New Orleans onto the 4th floor, and they are threatened and told that if you do not sign this consent, it doesn't matter whether they've done anything wrong, done something wrong, basically just been practicing medicine. They're told, if you do not sign this consent, we're taking your license. At the point when they are basically threatened into signing the consent, there's been no hearing. They have not been given their file. They have not talked to they have not been allowed to give their side of the story, and they are sent to the rehab without any hearing, without any trial, without having the ability to present evidence, without having a lawyer present. That's what's called due process. And when you were a prosecutor in the state of Louisiana, all of these were required by law before you could send anyone to jail. These are what they're doing to doctors in Louisiana who are not even accused of crimes. A complaint is made. In Dr. Stevens' case, and I wanted him to be more direct, the real answer is it was by an addict who stole his prescription pad, forged prescriptions, and ended up being charged with 6 felony drug counts. Her statement was taken, and based upon her statement, he was ordered to go to a rehab. No due process, no hearing, no confrontation, and basically was told, if you don't sign the consent, we're taking your license. That's not the way you prosecute. That's not the way you prosecuted people accused of crimes in your district. That's not the way people that are accused of crimes in Louisiana are supposed to be prosecuted anywhere. These are physicians who, and by the way, Dr. Collada said, first he indicated that people are given their investigative file court towards the end. Well, maybe before the hearing, he or someone else on the board can come up to the microphone because I am specifically questioning the accuracy of his testimony, and he can say on the record that Dr. Stevens can come get his file today. Since after all, we filed charges and threatened him with suspension and ordered him to go to rehab in the summer of 2014. Maybe today, he or someone on behalf of the board will say he can come get a copy of his file, which he has not received. And the statement, and by the way, and I want this to be on the record, the reason that this room isn't full of physicians ticked off is because they're terrified of Cecilia Mouton and the retaliation, and we'll provide more information on that. But with respect to the issue of due process, they handed you a piece of paper that they do not follow. And I think Dr. Feldman has some testimony.
Senator, just for recalibration purposes, this committee on all bills dealing with the medical board has asked that the authors not mention in particular staff's names and stick to a procedure. That's what the chairman established as protocol on everyone's bill.
Well, and I will say this, Acting Chairman, you know, the reason that this passed out of the Senate unanimously is because of the abuses and that were proven. And I understand that we haven't gotten far enough in this hearing to actually present all of the suicides, the doctors whose careers have been ruined, the employee who committed suicide after being berated by the board investigator. So I can use the initials. I'll say board investigator. I do want to say that when I refer to that it is Cecilia Mouton, and from thereafter I can just say the board investigator.
Thank you.
But there's already, not only is there doctors that have committed suicide, there is a former board employee that after being berated by the board investigator committed suicide, and there's multiple patients that have died because their doctors were precluded from continuing to render them treatment. So any pretense that this is about the patient, this is about Coach Cheney, this is about their power, their prerogatives, and their position. It's not about protecting the patients.
I think we were waiting on Dr. Collada to answer the question. It's been my practice, just from personal experience, that the physician does not, and maybe I'm wrong, receive, and you can come back to the table because we really need that question answered. I think that's the pressing question.
Can I respond to that so I can go sit down? That's the only thing I wanted to say.
I'm not sure. The board isn't clear, and we're not sure who has questions. I think it's clear, so right now, yes, you can.
There's two files. Just like you and I are both been prosecutors. You know, there's a file at the district clerk's office that's public, and then the prosecutor has his own investigative file. What they give you is basically the clerk's file. I've never seen my investigative file, and sometimes you don't even see it until you get to the hearing. So the answer is yes and no. You get one file, but you don't get the one you really need.
Dr. Stevens, what about the two patients?
And I'm not trying to put you in a bad position here, but that's why I asked for the complete file, and that's why I'd like to see, you went to Palmetto. I'd like to see what Palmetto has to say. Again, I want to give a fair hearing.
Those are medical psychiatric records,
and I
haven't seen them.
Chairman Hoffman in the chair.
I know you may not have seen them, but you certainly have access to them, and you're sitting up here telling us this committee.
No, I don't have access to them. I don't mind you seeing something I've seen.
Well, I can't imagine if you went to a hospital for drug treatment and you're coming before this committee, and look, all I have to do is go
Representative Johnson, we asked for his psych file from Dr. Hammond last week, who had the file there to basically blackmail Dr. Stevens, but refused to give him a copy of his own file. Now, that's the facts. That had happened in the hallway outside this committee room. If Dr. Hammond wants to come up here and deny that under oath, this is a great opportunity.
All I know is this.
Because he asked for his file, and Dr. Hammond said no.
If a physician is holding my file, and I go to his office and request a copy of my file in writing and sign that HIPAA release, and I pay to have a copy of my file, he gives me a copy of my file, or she gives me a copy of my file. And if there is some reason that that's not occurring,
HIPAA doesn't apply to their agency.
To who you're talking about?
HIPAA does not. I used to be a HIPAA lawyer.
And you were sent to the.
HIPAA does not apply to the PHP or any of that.
So you were sent there by the Board of Medical Examiners?
No, I was sent there by the PHP. The Board of Medical Examiners never issued an order about it. I was told by Dr. Mouton to go to PHP, and they said, here's where you're going. That's the way it happened. And the PHP is not covered by HIPAA. That's how this happens. I understand you think
you have no access to that file.
I asked for it last week, and he said he didn't think he was authorized to give it to me. And then Senator Milkovich started what I guess you could call a conversation about that.
All right, Dr. Collada's here. I guess you'll talk about that as well. I don't.
Well, I wanted to read from our established Title 46, and it says, Section 9916, Discovery. After filing a notice of an administrative complaint has been served pursuant to Section 9905 of this chapter, number 1, the parties or their respective counsel shall, within the time frames established by the pre-hearing conference order, provide the other with a list of all witnesses and copies of all exhibits that may be offered as evidence at the adjudication hearing. Respondents shall also be provided a copy of any written recorded statements that may have been provided to the board, or any exculpatory material the board may possess concerning the respondent. Number 2, subpoenas and subpoenas duties taken may be requested pursuant to 9917 of these rules, and discovery conducted in accordance with the Louisiana Administrative Procedures Act. So that's right out of our rules, okay? Before hearing.
Excuse me.
Is this before the consent decree or after?
It's my understanding that it's before the hearing, and I'd have to get an answer specifically about that. I'll get that for you, okay?
In terms of requesting medical records on behalf of a physician, they can't see their own medical records? Is that?
Again, the PHP is not...
And PHP is what for
the Physicians Health Program is not a function of the board. It is something that the State Medical Society established in conjunction with the board to prevent board actions in physicians who have substance abuse and other medical illness and psychiatric problems. It's not there to be punitive. Quite frankly, we don't, if they successfully complete the Physicians Health Program, we don't do anything. So again, it's not a board function, so I can't answer what the board says. I think that you have to talk to the PHP.
There's a gentleman raising his hand in the background. I'm assuming
I'm sure he'd be
he's with
happy
the
to
PHP,
testify.
and he'll testify.
Can I be excused, or do you want me to stay up here?
You can be excused.
Thank you, Mr. Chairman.
I just want to.
I'm sorry. Are you through?
I guess I'd like to hear from this PHP.
Well, you'll have a chance to if he has a card here in a minute. So let's move forward. Representative Jackson, you have a question?
Yeah, I just want to, Dr. Collada, and I'm sorry to explain, because nobody seems to know. I'm so sorry. It seems that, and I know we have a board member here that's well versed in this, but it seems that no one seems to know the investigative procedures. Do we have an investigator here?
I got one.
Okay, because I think they can clarify what every member of the committee has continuously asked about the procedure.
And I will say, I think this is a gentleman who's been with them for 1 year. It's 6 months. Okay. It's not Cecilia Mouton who's done the dealings that are
I understand.
give rise
and
to
you
this
know,
bill.
the chairman has asked us not to refer to personalities. Now, it's my understanding and my experience that the physician is not entitled to his or her file until such time as it reaches the board. Am I correct?
Mr. Chairman and members of the committee, I'm supposed to introduce myself.
Yes.
Warren Rivera. I've been at the board for 6 months. I am the lead investigator, and I'm one of the ex-DE agents that works for the Board of Medical Examiners. We were talking about, I think we're talking about discovery.
Yes, discovery doesn't take place until after the complaint reaches the board. Am I correct?
That is correct.
So during the consent decree process, the physician is not, the file is not available to the physician.
Well, I'm not sure I have an answer for you for that. I do know that...
Does the physician receive he or she's file before entering into a consent decree? Because there's no discovery process codified for them to receive their file before that.
I'm not sure I know how to answer that question. I do know that, as Dr. Collada had mentioned, there's a 6-month preliminary investigation. We do not give the doctor under investigation a copy of the file at that time until we can substantiate the complaint. Once the complaint's substantiated, it goes to the board to request a formal investigation. After it becomes a formal investigation, the physician under investigation has a right to counsel and all those things listed in that piece of paper. And at that time, I would think discovery is negotiated between the physician, his attorney, and the director of investigations and the board.
It's been my personal experience that the physician does not receive his or her record unless they have not agreed to a consent decree, and then the board, begins. The process begins on setting a hearing date and all of that. Now, unless something has changed,
I should know the answer to this, but I do not know when discovery takes place. I would think it happens before the hearing because the physician, as a defendant, so to speak, needs to defend himself.
Yeah,
so
if he or she decides to forego the consent decree and have a hearing, then of course, go ahead, Dr. Collada.
If they decide to go to a hearing, everything is given to them. Full discovery.
Oh, I know, but I'm saying to make a decision on the consent decree, the discovery is not given to the physician even if requested.
The information in the file is given to the affected practitioner. so that they know what we know and why we are proceeding with the
But
recommendation.
do they get their entire file? It's been my experience that they don't. I mean, from my experience, the investigator tells them what's in the file, but the physician is not given his or her entire file into the discovery process. The discovery process only is triggered by the hearing.
Well, again, I think that you may be correct, but all of the information in that file is given to them. Now, again, as a physician, I'm not a lawyer. I don't know the definition between a file and the information in the file, but the information in that file that may be pejorative or exculpatory to the physician is given to them, so they know what we know.
When you say, and I guess this is a specific question that the committee keeps asking, are they told by the investigator what's in the file, or are they given their complete file before the consent decree?
Again, I know that they are given the complete information in the file. Again, that's all I'm told, and I'm trying to get a straight answer from the council, okay? I'm going to get that for you. I know they're given all of the information. Now, again, you have a term of art that's different from a gynecologist term of art, okay?
Right.
And so I don't want to get them confused.
When we ask for discovery, we ask for it in writing, and we get everything that you have in writing in your file. My question is, and my understanding of it is, you do not get what's in your file in writing, the hard copy of your file, until a hearing is set and discovery is triggered.
Okay, an administrative complaint triggers discovery. And so it says that the parties or their respective counsels can get that information once the administrative complaint is filed.
And I guess this will probably be the question that solves all of this. What does the board consider an administrative complaint? Is it after the doctor has decided not to enter into a consent decree?
No, that can be before a consent decree.
Oh, so we just hadn't been following procedures then? Okay.
Listen.
I know you're new, and the
it's my
investigator sitting at the table is new, and so I'm not.
My understanding that the administrative complaint can take place before a consent decree. Okay. And
But do you guys offer consent decrees in lieu of an administrative complaint?
Yes, we sometimes
and
do.
So at that
but again,
point,
they're given the information in the file. Again, I don't know if they, I have to be honest and tell you, I don't know if they hand them a stack of papers or if they say, here it is, you can look at what we got. I don't know the difference, and I'm trying to find an answer for you. But I know they're given all of the information that we know, both pejorative and exculpatory.
Okay, thank you.
yeah, that's.
Okay, we have some others that would like to speak. President would like to speak in favor of this bill. Dr. Mark Pittman Broadcasting.
And Mr. Chairman, with all due respect, I think Dr. Feldman had been called, and I think his.
I thought he came. I'm sorry, he did not.
He came, but he did not testify because I
Dr.
think.
Feldman, come back to the table, please. Sorry about that.
My wife, Linda.
Okay.
Lady in the back is Dana. Dana Bramley. First of all, thank you for allowing me to speak.
Please identify yourself, please.
Just a little bit about me. I am Dr. Arnold Feldman. A little bit about me. I was born in Philadelphia, Pennsylvania. Don't hold that against me. I've lived down south for 37 years, I think.
You're the one to Super Bowl.
I understand. I came to the South. I went to Mobile, Alabama, where I met my lovely wife at the Mobile Infirmary in operating room number 4. We moved to Natchez, Mississippi, where I was not an anesthesiologist, the anesthesiologist for the entire town. I took care of the ICU, delivered babies in a place, and forgive my impertinence, where African Americans didn't get epidurals for labor and delivery. I insisted that everybody gets epidurals for labor and delivery. I worked myself to death. We have 2 children, 2 sons, and forgive me for my emotionalism, you'll see why. Our one son lives in Mobile. Our other son lives in Baton Rouge. And Mama wanted to be near the grandchildren, so about 15 or 16 years ago, we moved to Baton Rouge, Louisiana. And my son Brandon worked for a big real estate company, and he found me a building, and I said, this is a town that needs my services. I'm an expert in anesthesiology. I have pioneered minimally invasive laser spine surgery. I had a pain clinic before anybody knew what a pain clinic was, not an opiate clinic, a clinic where we made a diagnosis, made reasonable treatment, and rescued people. I, at one time, was a good friend of Cecilia Mouton, and I won't say anything deprecating about her personally. I always tried to follow the rules to a fault. My clinic was 22,000 square feet across from the state police headquarters, 2 buildings, 2 MRI scanners, a CT scanner, a laboratory, a social worker, 63 employees and their families I took care of and provided health care for them and their families. And I had an extended family, including my patients, of probably a couple thousand or 3,000 Louisiana citizens. So my mama, who died in Louisiana, said to me, you know, Arnold, you should be proud of yourself. And I said, well, Mom, you put me through medical school. One day in 2013, I ministered to a patient who was a friend of mine, and we won't say his name. It is important, but it's not important for these hearings, and he died under my care. I insisted on an autopsy because that's never happened to me, although I've been in gunshot wounds, motor vehicle accidents, seen people die from cancer, sat with them when they died, took care of their pain, made their lives better. The autopsy, which was conducted in the East Baton Rouge coroner's office, of which I knew no one, said he died of natural causes. The pathologist, whose name was Cameron Snyder, didn't know him, said to me, I ran into him at a supermarket one day. He says, you know, Dr. Feldman, you don't know me. And he said, listen, I know you feel bad about that, but if this supermarket had a fire, this man probably would have died running to the door. His heart was that bad. So I felt that, well, I didn't feel good about it, but I reported it as required by state statute. Simultaneously with that, I was appointed to the Physicians Health Foundation, and we minimize that, but this is an important aspect of this. I was appointed to the Physicians Health Foundation by the Louisiana State Medical Society, of which I was a member since the day I came here. They asked for volunteers. I volunteered, and it is my nature to help people. So I said, what better way than to help your colleagues? Like you said, you want them to be the best that they can be. And I felt that that was a good thing. The next thing you know, I find out that evil lurks somewhere in the halls. I was appointed to the Physicians Health Foundation. 3 months later, I thought to myself, did I miss the meeting? They had a secret meeting, and I was voted off the board. Now, they couldn't have hated me because I didn't know anybody on the board. But my investigations found that most of the people on the Physicians Health Foundation were impaired. I was not impaired. And somebody directed them to have a secret meeting and vote me off the board, and I found out why. The seat of power, which we heard some testimony today, the seat of power of the medical board is to accuse physicians of being impaired. If they accuse you of being impaired, you must consent without a reasonable trial, without exculpatory evidence being released to you, which we just heard, until it is so late in the game that you are either beaten down, financially indigent, or commit suicide. I spent $1 million on lawyers. I know more about this process than anybody in this room, including the lawyers for the board, because I have been through it. And I will tell you this. The Constitution of the United States is about 4,400 words. There is no due process in that place. What this bill purports to do, a Physician's Bill of Rights, we need this. I won't say much more. We need this. The Senate, despite some mild opposition, voted unanimously to pass this. You mentioned, I think, your relative or daughter-in-law. I have saved people's lives. I get phone calls every day. And just so you know, I was a moderately successful physician financially, not a rich guy. As my decorator said, just rich enough not to embarrass my rich friends, of which I have no friends anymore, except a few. I don't have a home anymore. I don't have a car. I'm essentially homeless, living in a motorhome. I lost my license in California, Mississippi, Alabama, where I pioneered, where I invented spinal instruments, where I teach surgery. And they have accused me, they basically photocopied the charges against me. No consent agreement. I was never offered a consent agreement. And the reason being was, what did I do? I'm not impaired. I'm not a drug addict. I'm not a drunk. I don't drink. I work 7 days a week, 365 days a year. I come home 10, 11 o'clock at night, and my poor wife, a nurse, puts up with this nonsense, or used to. And now I couldn't find her a doctor. She has some health problems. We had to go to Maryland. I had to drive 1,200 miles to Maryland every 3.5 weeks so she could see a doctor. So I'm a homeless, unemployable, Harvard-trained physician, the best in his field that this state has ever seen. And I'm not an egotistical guy. I'm just looking at the landscape. I'm the one that would never have an MRI on somebody with a metal object in their head without doing a CT scan first. But I watch my MRI scanner for $2 million and my CT scanner for $1 million get packed up in a box and go to Dubai. Because I lost my building, I lost my home, and I lost my ability to take care. The most severe thing is I lost my ability to take care of the people that need me. Some of them couldn't be here today, but we spoke on the phone. And they wish they could, but they are too sick to come. So what I tell you is this. I sat in a hearing for 3 days at 630 Camp Street, which is, by the way, the most heavily fortified building in the state of Louisiana. You can't get in there. There's armed guards after armed guards and bulletproof glass and elevators. And my poor wife, when we had my hearing, we don't like to be tried in the dark. I think in the American justice system, the courts are open. Anybody can go and sit in a courtroom. Just like this chamber is open. They made her sit on the street corner in Louisiana, in New Orleans, in the middle of the night. While I stewed for 3 days, and I said to my lawyer, Joe Bruno, who's a smart guy, and Joe said to me, "Oh my God, I've never seen anything like this in my life," but he was trying to, preserve my license. But Joe was good enough to discount every charge that they made against me. But it didn't matter because the decision was predetermined. And that's what you don't realize, is that all of these decisions are predetermined by a nefarious group of people who love power and money. So let me just tell you about the money. The governor makes $127,000 plus dollars. An appeals court judge gets $159,000 or $157,000. Cecilia Mouton gets about $300,000 with benefits. I believe her niece is over there, and she has a job for $108,000. The law firm of Adams and Reese gets $2.5 million. Rick Stanley and his little law firm gets $1.3 million. The unlicensed investigators get over $100,000, and I think you guys and ladies are getting $16,500 plus a small amount of expenses, right? Now, in the midst of a budget crisis, for years they voted themselves raises. They voted themselves raises. And if you look at the lawsuits, Parker versus Mouton, Michelle Parker, I spoke to a minute ago, she couldn't be here. 10 black employees were fired in one day or a short time. And why were they fired? Not because these were decorated, hardworking people. Why were they fired? To support the high salaries and the legal fees. You as a lawyer would be shocked. There's no due process. And the reason these people signed those consent forms because they had a gun to their heads. And if you look at the bottom of most of them, you waive your constitutional rights at the end of it. You waive your constitutional rights. And I don't think any American should be made to waive their constitutional rights to support their families. And that's why these people committed suicide. I wake up every morning and I think about committing suicide. You know what? But I'm not gonna, because this woman here needs me. My children are sufficient. Although they would be depressed, they don't need me to survive. My wife has developed so many illnesses as a result of the stress of this and the loss of her home. And I will ask you in a very short way, do not believe what they tell you. And if you want to see documents, I got 11,000 pages of them for you. And please come to my Fourth Circuit Court of Appeals hearing, which I'll announce the date. I would like all of you to come. Then let's see how the cow ate the cabbage, I think, as the saying goes. But I want to leave you with a couple of things. Number one, the Dr. Suicides will continue. I hope I'm not one of them, but you will see more. Number two, I want to introduce you to Dana in a minute, which was the center point of my prosecution, and I want to talk a minute about Tanya James. As a prosecutor, I'm sure you do everything you can to make your case work, and so does the defense attorney. But you need evidence, and you need to exchange evidence. And what Representative Jackson was saying is absolutely true. You don't get the evidence. So I sat there in a hearing where they had a fake judge that gets $250,000, and he was a reasonable guy, but, some people will do things for $250,000 that they might have not done otherwise. And I had a fake judge, and so the lawyer for the prosecutor is like the DA, is also the lawyer for the board, who is the jury. And then the judge, we had an old judge named Judge Ellis, who was, I think, a pretty respectable guy, and he said in the beginning, we're going to give you all the discovery you want. And then he was overruled by Dawson, the president of the medical board, who substituted himself as a judge, and then the lawyer for the investigator became the lawyer for the jury and judge. And so what I'm saying is this is an anathema. This was said no in Haygood versus the Louisiana State Dental Board. And you guys came and passed a law, 843, which became 441 in 2014, and they came here and swore that they were going to straighten out these problems. But guess who was the last person that was prosecuted under the old rules? Arnold Feldman. That's called a bill of attainder. That's not even legal. They prosecuted me. I had no due process. There was no judge. The jury was the judge was the jury. And my brother, who's a pretty smart guy, says, you know, they could have taken the janitor and put a black robe on him. Would have been the same darn thing. You probably would have gotten a better shake. And so the point of the matter is that I can tell you right now, there's no due process there. There needs to be legislative oversight. Do not believe what they tell you. And don't think I don't respect Dr. Collada, because I do. And he's new there. But how can you take everything I earned and everything I worked for? That is my property. That is constitutionally guaranteed by the Constitution of the United States and the Constitution of the state of Louisiana. And I am homeless at age 63 and unable to get a job in Louisiana, Alabama, Mississippi, the other states, Puerto Rico, Guam, and American Samoa. I can't get a job anywhere. So what am I supposed to do with my Harvard education? Well, I'll tell you one thing I did at the behest of this man. I went to church. Thank God for that. But God has empowered me with a brain. And see, you ladies only hear this stuff. I went through this for 3.5 years. Now, if I was a bad doctor, and I don't disagree with this, they should have the power, if somebody's really bad, to suspend their license summarily pending a hearing. They should have that power. If it's why did it take them 3.5 years to take my license away? You know why? Because this is what it is. And I want you to hear this very short. They're not truth seekers. They're case makers. Understand the difference? So I'm a victim, and my 1,000+ patients are victims, and my wife is a victim, and Dana, who wants to speak, is a victim.
Right there, it's right there.
Where? Oh, there you are. Okay, Dana was my right-hand person, and I'm going to leave it to Dana, and then I need to say something about Tanya James. But I was traveling back and forth to Linda's doctor, and I passed a place called Lexington, Virginia, and we went to the house of Stonewall Jackson. Those of you who have heard of Stonewall Jackson, I didn't realize this. He was shot by his own troops. They had to amputate his left arm, and Robert E. Lee said, he lost his left arm, and I lost my right arm when he died 8 days later. Dana became the target of the director of investigations, and you look at Dana. Dana comes from a big family, a very, very, very prominent family, and they looked at her, and despite her being a disabled American, they forced me to fire her in the middle of the night. Now, what due process, what authority does the director of investigations have to force a Louisiana citizen to fire a disabled American employee? Can you come up with a statute? Is it 49,964? Is it 37,1252? I do not know. But this is what happened to me. And one other thing, I had a patient that and I have to say this because her daughter asked me. I had a patient that was 40 years old, kind of like your relative, and she had four surgeries by a surgeon who operated on her December 31st and then moved out of town. Where's the medical board there? And he destroyed this woman's life. So I rescued her, and I implanted a spinal cord, a spinal morphine pump, of which I am one of the world's experts, not a local yokel. I'm a world's expert in this. Dana has one. And she got better. And they pulled her aside because she was vulnerable because her house burned down. Her name was Tanya James. And they went to her and they said, listen, we want to get Dana, because Dana was my right hand, like Stonewall Jackson. And she helped me maintain these pumps, of which I had 250 patients. That's a lot for one guy. I mean, in that type of thing. It's very labor intensive. But Dana was my right hand. My wife was also my right hand. So I had two right hands. And so they went to this girl, Tanya James. They said, listen, we're going to get Dr. Feldman, and we want you to snap pictures without a subpoena, HIPAA violation, and they promised immunity to these people. Where's the due process there? And so she did that, and then she went to the pharmacy. She left my practice, and I thought to myself, because I knew my patients pretty well, I knew what they had for breakfast, most of them. And I said, where's Tanya? I hadn't seen Tanya in about 3 weeks or a month. Oh, she's left. Well, I said, what do you mean she left? So I go to the pharmacy where she went, and they said, oh, she went. The board told her to leave you, that they're going to take your license away. This is before I even had a trial. And she wound up dead 2 days later in the trailer of one of their paid informants named Andrea Heimbach. I want to repeat that. She wound up dead in the trailer of one of their paid informants in Livingston Parish, I think. So I went to the coroner, a guy named Coe, who I don't know personally. I said, I want to see the autopsy report. Well, we didn't do an autopsy. I said, what do you mean you didn't do an autopsy? Oh, well, she was a drug addict. I said, really? So after I sent a private investigator over there to get the autopsy report, I said, okay, well, you say she took too many pills. Where's the pills? Oh, we flushed them down the toilet. So what I'm telling you is this, is that we heard a little testimony. I lived through this, and you see what happened to me. Harvard-trained physician, unemployable. Dead patients at the hands of this medical board. No due process, no records, no nothing. Hearsay, they convicted me. You read what they wrote about me, it looks like I'm like Jack the Ripper, but I'm really a good guy, and I can help people. And so my license is up, my suspension is up. I lost everything. I lost a $10 million building. I couldn't help you get to your car at this point. But in 6 months, when my suspension's up, they're never going to give me my license back. That's like Charles Manson getting parole. It's never going to happen. You know why? Because I challenged them, and I'm telling you the truth. So if you'll do for me one thing, look at your senator compatriots who passed this bill, I think 36-0. 36 to, now you guys are every bit as experienced and smart as they are.
Smarter.
And smarter. I'm sorry. I'm not politically correct. Smarter than they are. And they were undaunted. They were not dissuaded by, oh, I think the rules say this and I think the rules say that. And if you will take what I say, and you don't have to believe me, ask Steve Carter, who was one of my good friends and a patient. Ask Franklin Foyle, who knows me well. I could give you the names of many, many people that know me well and looked at me as a verifiable person, as a generous person, as a hardworking person. And if don't do it for me, my life is destroyed. Do it for the future. Do it to prevent any more of these things that we're talking about, the suicides. Do it for Dana Bramlett, who lost an $80,000 a year job and now can't support herself. By the way, she was the sole provider. Her husband had kidney failure and was on dialysis. She was the sole provider. And I said to them, how can you do this? She's the sole provider. Didn't care. So the point of the matter is I care, and I know you people care. And the one thing I love about big government buildings is I always tell people this, because I've seen it. You know, it's nice that you spend our tax money on marble floors and things like that, but you know what? If somebody drops a little drop of water and you slip, you're going to be one of my patients. But the bad part is I can't help you anymore. But maybe one day I'll be able to resurrect myself with your help. And if not, then I will be a fading memory. But if you can't do it for me, and I don't expect you to, but I am a citizen here, if you'll please do it for yourselves and your children and the rest of the people in Louisiana, and that medical board, you know what? You want to straighten it out? Put me on the medical board, because I know how things should be. And doctors are generally good people and shouldn't be made to commit suicide. But I've got to tell you right now, it's bad enough dealing with the federal government, bad enough dealing with Blue Cross, bad enough dealing with sick people, bad enough dealing with cancer. And when you do that 57 times a day, and then you got to deal with this, you can see why these people are pushed over the edge. And you know what? This is what I say.
We have a question for you. Is that
Go ahead.
okay?
I'm sorry.
Okay.
I'm finished, and thank you,
Representative Johnson.
for my
Dr. Is it Farber?
Feldman.
Feldman. It's Feldman?
Yes, sir. Farber was one they got a few years ago.
Okay. Then I'm going to withdraw my question.
Okay. Mrs. Feldman, did you want to speak?
Well, this is all out of my element, but he's probably said everything that I needed to say. But I mean, I want to back up what he said. I went through this. I've been through this with all of him, and there is no due process in this whole process. So I kept saying, how can they accuse you of anything with no evidence? I kept saying, just show me just one piece of evidence, and they didn't show anything. So, I mean, they've accused this man who has dedicated his life to his patients, and he loves his patients, they love him, and they're all lost without him. And honestly and truly, I mean, this whole board, they need to be revised. I mean, because I've never seen anything in my life to how you can, convict somebody of a crime and not even have one piece of evidence, due process at all.
Thank you, ma'am.